Hello, Omaha, and welcome back to Keep Moving Forward, a table talk for the City of Omaha Human Rights and Relations Department. I'm Lori O'Brien.
And I'm Laura Aite, and we work in the Civil Rights Enforcement Division for our department. We are responsible for the investigation of complaints of discrimination under federal and local laws, and these laws protect individuals from discrimination in housing, employment, and places of public accommodation. If you believe you've experienced discrimination or simply need more information on your rights, please contact our office at 402-444-5055, or you can visit our website at humanrights.cityofomaha.org. Thank you for joining us last week, where we heard from special guest Dr. Franklin Thompson, who is the director of our department. So today, in honor of April being Fair Housing Month, we will be talking about hot topics in fair housing. The Fair Housing Act was passed in April of 1968, so this month we have a 53-year anniversary of the Fair Housing Act. Yep. So I think the first topic that we wanted to cover was applicant screening criteria, right? In terms of renting housing, or even, trying to purchase a home as well. And one thing that relates to that is criminal background screening. A couple episodes ago, we did cover the basics of fair housing laws, went over the protected classes that the law prevents discrimination. Mm-hmm. So while criminal background screening itself is not a protected class, it can be related. I think that first, to kind of explain how that relates, is just to cover two different types of discrimination theories. The first is what they called disparate treatment, and disparate treatment is treating someone differently because he or she is a member of a protected class, and so this involves discriminatory intent. Now, the other type of discrimination is what's referred to as disparate impact. Mm-hmm. And this is different in that it's typically a policy or practice that's neutral on its face, but disproportionately impacts a protected class and does not require discriminatory intent. And so criminal background screening sometimes can have a disparate mm-hmm. impact on certain protected classes. Right. Yes. And so it's not protected itself. However, the Department of Justice has said that 1/3 of the population of our country actually has a criminal record of some sort. And
that's a lot.
Right.
Right, when you think about it.
Mm-hmm. Yeah. And so a lot of people are affected by strict background mm-hmm. screening policies in terms of housing. It can restrict people's access to housing. Mm-hmm. Right. And so, and whether that could possibly be discrimination or violate the Fair Housing Act kind of relates to certain protected classes being overrepresented in that area. HUD and the Office of General Counsel, they've said that African American individuals and Hispanic individuals and people of color are arrested, convicted, and incarcerated at rates that are actually disproportionate to their share of the population. So that's what we mean by being mm-hmm. overrepresented. Right?
Yes.
And so when we look at that and whether or not a criminal background screening is legitimate or could possibly violate the act, what we want to see is, if that policy or practice restricts access to housing on the basis of criminal history, if it has a disparate impact on individuals of a particular race, national origin, or any other protected class, and it could be unlawful under the Fair Housing Act if that policy itself is not necessary to serve a substantial, legitimate, non-discriminatory interest of the housing provider, right?
Yes, yes.
And another thing we have to look at is whether that policy or practice, if a different policy or practice could serve that same interest and have a less discriminatory effect on that protected class. So, Lori, what do you think are some things that landlords should consider, when implementing criminal background screening policies?
Well, I think they have to, if they're going to have like you said, a policy or practice, it needs to be across the board for everybody, but they have to take into account, what kind of record, maybe, what is the record that's affecting that person? Like, is it a misdemeanor? I mean, what type of criminal background are we talking
Yeah.
about? There's the difference between a misdemeanor and a felony.
Sure.
So I think that's something that the landlords have to take into consideration. I think sometimes, how long ago was the offense?
Right.
I think that's something that they should take into consideration. Sometimes there's things on somebody's record that they might not even know about.
Right.
Some things that the individual doesn't know that's on there. They should have a chance to explain that to them.
Sure. I agree.
Just like on an application. I just think that should be more of an interactive process with the landlord and the prospective tenant.
Right.
And more dialogue on this, and not so cut and dry.
Right. I agree, and that kind of, brings us to one thing, some guidance from HUD, who, they enforce the Fair Housing Act. Some guidance from HUD has stated that, a denial or a background screen that's based solely on arrest records is not valid, right? Because it kind of all comes down to whether or not that criminal background screening policy serves a legitimate non-discriminatory interest for the housing provider.
Right.
And I think typically the reason for that, when they have criminal background screening policies, is for the safety and protection of residents
right,
and the property.
Offender, right.
And so really what a landlord or housing provider would need to look at is if that policy is really achieving that.
Good point.
And for that reason, I think arrest records typically, just arrest records really wouldn't serve that purpose.
Absolutely.
Right?
Yes.
And so as such, the criminal background policy should be based off of convictions and not arrests.
Right. Absolutely.
Right.
And I actually have a case example of this situation. So it was the case was the Fortune Society versus Sandcastle Towers Housing Development Funding Corporation. And this was out of the United States District of Eastern District Court of New York. So on October 30th, 2014, the Fortune Society, which is a nonprofit organization that provides temporary and permanent housing to hundreds of formerly incarcerated individuals, they filed a suit under the Fair Housing Act. So they alleged that they were trying to rent apartments for its clients at Sandcastle, which is a multi-building apartment complex that the defendants own and manage in Queens, New York. When the defendants learned that Fortune was seeking housing for the formerly incarcerated individuals it serves, they refused to rent the apartments per the defendant's policy, prohibiting anyone with a criminal record from renting an apartment or living at Sandcastle. This ban, Fortune alleged, was discriminatory and had an unlawful, desperate impact on the basis of race and color. So on July 3rd, 2019, the court issued an opinion denying the defendant's motion for summary judgment on the plaintiff's desperate impact claim and allowing that claim to proceed to trial. So it actually went to trial. And the case was settled in October 2019, with Sandcastle's owners agreeing to pay $1,187,000, which is one of the largest settlements in this case, challenging the ban on renting to people with criminal records, if not the very largest. An update, the owners have ended up selling the building and they don't currently own any real estate or rent any real estate. So that just goes to show you, the Fortune Society was trying to do a good thing, get these individuals back into the community. Mm-hmm. Housing is something that they need to secure.
Yeah, definitely.
And they found out that this respondent was discriminating against them because of that.
Right. Yeah, I think this was a really big case.
Right.
And we don't see a lot, as of yet, we haven't seen a lot of cases go to court with the disparate impact theory.
Absolutely.
And so I think this was big and important because it just highlighted that while it can be, a criminal background policy can be necessary,
sure.
It also can greatly restrict a person's access to housing. And as you said, everybody needs a place to live. It's very important to find housing where you live is important. It impacts so many different aspects of your life.
Absolutely.
So
yeah, it's one of the basic needs that an individual needs.
Of course,
to secure
right.
housing.
Yes.
And these individuals had served their time, they did their, paid their dues, and they were just trying to get back into a community and become self-sufficient.
Right. Yeah.
Yes. So I think the next topic we wanted to talk about was familial status. And the definition of familial status is the presence of a child under the age of 18. This law is designed to protect families with children, as well as anyone who has legal custody or written permission to have a minor child living with him or her. This law also applies to pregnant women and anyone in the process of obtaining legal custody, such as adoptions or through divorce proceedings. Now, there is a housing for older persons exemption, so communities serving individuals 55 years or older are exempt from this. And some examples of familial status discrimination might be steering. So maybe a couple or a single mom with kids goes and applies for housing at an apartment complex, and the landlord is trying to steer them to a building that just has children.
Right.
Because the other tenants they do not want to live in a building with children maybe above them, to hear the running. And
Sure.
so that would be an example of steering. Or maybe a property owner has specific rules only for children. So those would be two examples of discrimination
Right.
that we see.
Yeah, and
a
I
lot.
think, yeah, definitely. And I think that sometimes, both tenants and housing providers maybe aren't aware that familial status is
Good
actually
point.
a protected basis
Yes.
under the Act. And so, with the rules have to be the same for everybody.
everybody.
You can't just have specific rules for
Right.
children.
Right.
Yeah.
Yes. Good point, Laura.
And I think another thing that a lot of people want to know when it comes to familial status is occupancy standards, right? And that the reason is because there are state and local laws that limit occupancy based on the number of people per square footage in a place. And so sometimes we'll see, an apartment or house that's for rent and will only allow a certain number of people in one bedroom. So perhaps you might have a couple with a newborn baby wanting to rent a
Sure.
one-bedroom unit, but the policy is that only 2 people are allowed per bedroom. And so while that in itself may not necessarily be unlawful or discriminatory, it kind of depends on quite a few factors.
Right.
But the occupancy standards, it can impact families
Absolutely.
with children.
Absolutely.
So, occupancy standard policies are allowed, but they should not unreasonably deny families. And this kind of goes back all the way to 1991. So HUD's general counsel at that time was Frank Keating, and he wrote some guidance on this, and it's now, it's been known as the Keating Memo for a while, and it gives us some guidance on fair housing enforcement regarding occupancy restrictions and whether or not they're reasonable for families with children. And so this is information for both tenants and housing providers. And so under the Keating Memo, HUD considers it to be reasonable that two people per bedroom is a reasonable rule.
Yes.
But it's not necessarily a hard and fast rule.
Right.
Right? That shouldn't be the only standard. And so there's some other factors that a housing provider may need to take into account when determining how many people can be allowed in a unit or in a bedroom. So some of those factors when making those decisions include the size of the bedroom or unit, the age of the children. For example, a baby might need to be in a one-bedroom unit with their parents,
Right.
in the same bedroom with
Right.
their parents, right? And I think that would be reasonable.
Yes. But 2 teenagers of
Right, yeah.
Might be a
Or
different-
3 teenagers
or
in
3,
one
yes,
bedroom.
yes,
Right,
yes.
yeah. The configuration of the unit, other physical limitations such as sewer and building systems, state and local laws regarding occupancy restrictions or standards. And lots of times we see these laws just as just a means of safety, fire safety, right? If you have too many people in a bedroom and there's not enough square footage, it could possibly violate building code
Yes.
or fire code. Could be a safety
Yes.
hazard. And I think that is one reason we see a lot of the occupancy restrictions.
And you hear those horrible stories of that.
Right.
Something happened, and there was a lot of people
Yes.
in a
Yeah.
home.
Right.
Yeah.
And so Again, that's not a hard and fast rule, but just some information that housing providers and tenants can take into account in terms of for families with children.
Right.
Yeah.
Right. So, and then on another topic that we wanted to discuss today is reasonable accommodations, which is a very hot topic and something that we always get calls on. There's a lot of questions about what is a reasonable accommodation and how does that take place, in regards to housing. So the definition of a reasonable accommodation is a change or exception to a rule, policy, practice, or service that may be necessary for a person with a disability to have equal opportunity to use and enjoy a dwelling and its common use spaces. Some examples of a reasonable accommodation might be pet policies and assistance animals, maybe transferring to a different unit. So somebody who may be on the second floor and has mobility issues maybe wants to transfer to maybe a first floor unit, or unassigned parking. There needs to be an interactive process, and by this what it means is if a person requests a reasonable accommodation, they need to, the landlord and the person that's requesting it, the tenant per se, they need to have kind of a dialogue, a discussion of what the request is, and whether it is reasonable for the landlord or property owner to provide that accommodation. And if not, if there's an alternative accommodation that maybe they could use instead to accommodate that person with a disability-related need. So there has to be a conversation. That can't just be a hard and fast no. There has to be trying to come to maybe, some type of agreement on that. Now there is an obligation to provide prompt responses when somebody does request a reasonable accommodation. And we find out that, sometimes a property owner or a landlord might have an undue delay in responding to a reasonable accommodation request. And this would be deemed as a failure to provide a reasonable accommodation request. So somebody might submit a accommodation request, and the landlord may take, months and months, or maybe not at all. We've seen that too, where the landlord just totally ignores the request, and that is
no response.
Yes, what we would call an undue delay.
Right.
Now, it's important to point out that a reasonable accommodation is a case-by-case basis, so it's not everybody is on the same page, across the board. You have to take into consideration every case. So that is something that, you want to keep in mind when you are requesting it or you hear about a reasonable accommodation. Right.
Yes, and all this information and guidance can be found, from HUD and the Department of Justice have issued some joint statements giving guidance to housing providers in this, because it is a complicated area of the law.
Absolutely, very much.
And so, if anyone has questions, there are resources out there which we can always provide to anybody that calls our office. So as Lori mentioned, one type of reasonable accommodation that is very common is a request for an assistance animal.
Yes.
And so that would be an exception to a no pets policy, right? And lots of times we hear emotional support animal, comfort animal, service animal, and it can get very confusing as to what's the difference between all of these.
Absolutely.
And different laws stipulate different definitions of these. But for purposes of the Fair Housing Act, HUD doesn't necessarily distinguish between these. They lump them all into what they call assistance animals, and that's defined as an animal that works, provides assistance, or performs tasks for the benefit of a person with a disability, and that provides emotional support, that alleviates one or more identified effects of a person's disability. And so it's important to know that if a person has an assistance animal, a housing provider cannot charge pet deposits or fees, even if they initially have if they have a pet policy that they allow pets, but they have fees and deposits, can't be charged for an assistance animal, because an assistance animal is not a pet. Right. It's actually a tool to help someone that has a disability. Some other things that are important: the animal does not have to have certification or special training, and animals can't be limited solely due to breed, type, size, or local ordinance bans. But some things that a housing provider might want to know they can do They can require that the tenant maintain control and custody over the animal, clean up the waste, and ensure that the animal is not a direct threat to the health and safety of others. That would need to be considered on a case-by-case basis. Right?
Yes.
And one thing that I wanted to kind of talk about in regards to reasonable accommodations is what you had mentioned, which was an undue delay.
Yes.
Had a case example that I wanted to bring up that could have possibly been an undue delay. So this was a housing complaint that we had where the complainant filed a housing complaint against a multifamily apartment complex where she rented a unit. And she had requested a reasonable accommodation for a handicap parking stall due to her disability. And she had alleged that she was never given this or she was never granted this. So it was revealed that initially the respondent actually agreed to provide her with the reserved handicap parking stall. However, they then failed to take any steps in order to actually provide the accommodation, take any steps to actually install the reserved handicap parking stall, despite multiple follow-up inquiries about it. Really what the housing provider needed to do this would have been to install a sign in the ground, a handicap sign that said it was reserved for this individual's unit, adjust the lines on the cement make sure that the size of the parking stall fell within ADA guidelines, and also that there was an access aisle. So these were some things that they needed to do. However, it was nearly 3 months after they had agreed to grant her the reasonable accommodation, and had taken absolutely no steps to do so. So ultimately, the parties were able to reach a conciliation agreement to resolve the issue. And so it had not gone to determination, but it's just possible that if it had, it could have been considered an undue delay. Right?
Yes, absolutely.
So that's just something that we see.
Yes.
An example of something that we see in our office.
Yes. So just saying yes to the accommodation and then not doing anything about it. Yeah, that's
exactly.
a definite failure. And then I have also another case that was filed in North Dakota District Court. The case is called the Fair Housing of the Dakotas versus Goldmark Property Management Company. And this was back in 2011. So the plaintiffs, Fair Housing of the Dakotas, filed action against Goldmark Property Management, alleging Goldmark's assistance animal policies discriminated against individuals with disabilities. The plaintiffs alleged that Goldmark imposed fees on the tenants with disabilities who resided with a non-specified training assistance animal or a companion pet. But these same fees were waived for tenants with disabilities who resided with a trained assistance animal, so a seeing eye doctor or eye dog. So they were imposing fees on a assistance animal, which is a companion pet they called, but they were letting people with a seeing eye dog. They were not imposing fees to those animals. So it went to court, and the court ruled that the Fair Housing Act encompasses all types of assistance animals regardless of training. Therefore, Goldmark's policies implicates the Fair Housing Act. And the court granted Goldmark's motion for summary judgment as to the plaintiff's claim of desperate treatment because no proof was offered of intent. However, the court denied Goldmark's motion for summary judgment as to the plaintiff's claims of disparate impact and failure to make a reasonable accommodation. So they cited, you can't just impose fees on one animal, a companion animal, which they say most times you hear, oh, that's just a pet.
Right.
But a seeing eye doctor, or I want to keep saying seeing eye doctor, seeing dog, is a service animal, so therefore they say that was under the Fair Housing Act, and that one they did not impose the fees. So
so it's really important to
distinguish.
That to be educated that under the Fair Housing Act, they both, the rules apply the same for both an emotional support animal or a service animal. The rights are the same for those. Yeah.
And I think it's important to bring up too, Laura, like when we have cases like this where there is not a lot of education, I mean, that's something that we provide to the respondent so they can get that education so it doesn't hopefully continue to happen to the next tenants That they know what the Fair Housing Act implies to all these, reasonable accommodations and everything else that we discussed, so they do become aware of what
Right, yeah, because
the law is.
Yeah, and as we said, it's a complicated area.
Yes, very.
And, it can change based on case law, and so it is important just to stay updated and have continuing education on this issue of your housing provider.
Yes, yeah, so.
So it looks like we are probably out of time for today.
Yes.
Right?
We could go on and on about
Yeah,
this
we have a lot more we could talk about, but I guess we'll have to stop for today.
Right. So we want to, again, bring up that if you feel like you have experienced discrimination, to call our office at 402-444-5055 or visit our website at humanrights.cityofomaha.org. And I'm Lori O'Brien.
And I'm Laura Aite, and this has been Keep Moving Forward.